Sorry, we're a few minutes late.
It's entirely my fault, Mr. Reedy.
No apology necessary. It was nice to have the extra 5 minutes. My lords, my lady, this morning I'm going to deal briefly as I may, with, just want to finish off one point about the list of circumstances in which the domestic courts have been sucked in, if that's the right way of putting it, sucked into the area of torture and matters of that ilk. One small point on that, and then I'm going to come directly to the Court of Appeal's 6 reasons for effectively applying the public policy against us in this case, if I may. The short and final point in relation to that list was that the Court of Appeal placed some reliance, as you will have seen, on A number 2. And A number 2, as you will recall, was the case about whether or not evidence that might or might not have been obtained by torture should be admissible into SIAC proceedings for the purpose of establishing whether or not a reasonable belief in acts of terrorism had been made out. I'm not going to invite you to turn it up, because I'm sure the facts will be well known to my lord, to my lady. For your note, it's in Authorities, Volume 5, Tab 45, MS 3232, and it's dealt with in the Court of Appeal's judgment at paragraph 90. My submission on A number 2 is that it is merely an example of a specific context in which, for the purpose of assessing the admissibility of evidence in SIAC proceedings, the court would have to make a judgment about whether or not the evidence had been obtained in a particular way, in that case, contrary to UNCAT. And they placed particular reliance, as you will recall, on Article 15 of UNCAT, which had UNCAT has a specific provision in Article 15 that says a domestic court cannot admit statements that have been obtained by torture. So the 2 issues, in a nutshell, for the House of Lords in that case were whether or not that should apply. In other words, should torture evidence be treated as inadmissible for the purpose of SIAC proceedings, despite the fact that the SIAC procedural rules allowed for a broad swathe of evidence to come in, not necessarily restricted to evidence which would otherwise be technically admissible in a civil process. That was, as it were, issue 1, and the House determined unanimously that the rules should be qualified in that way, so as to preclude the admission of evidence that might have been obtained by torture. And the second issue, which was the one that divided the House, effectively 3-2.
4-3, I think.
Yes, 4-3, my lord, you're entirely right, I'm so sorry. But a pretty powerful...
Was the standard of proof?
Was the standard and burden of proof point. And so far as that is concerned, as you will recall, pretty powerful-looking minority, it might be thought, comprising Lords Hoffman, Nichols and Bingham, concluded that the answer to that question was that it was enough to render the evidence inadmissible if SIAC was, after conducting its own semi-inquisitorial role, given that there were closed proceedings involved, it was enough if it could not be established that there was not, for it's a double negative, but the double negative is taken from Lord Bingham's speech, if it could not be established that there was not a real risk that the evidence was obtained by torture, and the majority, led by Lord Hope, concluded that it had to be established on the balance of probabilities that it was obtained by torture. So that was how it divided. But in essence, we respectfully submit that that is an example of a very specific context involving both a direct provision of UNCAT, which they place considerable reliance upon Article 15, but more importantly, deriving from the need to design rules for the admission of evidence for the purpose of those special SIAC proceedings, and isn't, therefore, authority for any broader proposition, so as to, as it were, open the door to a position of principle that allows domestic courts to rule on the legality of actions of foreign states, which is the issue that confronts us here. So can I come then directly to the Court of Appeal's 6 reasons? They are contained in their judgment at paragraphs 115
Yep.
it's really 150 to 120 are the 6 reasons identified.
Yes.
We looked at 114 yesterday. But so 115 is the first of the reasons. I hope a fair summary to say fundamental change in public international law.
Yes.
My submissions in relation to that, or my core submission in answer to that, is that the change, such as it is neither so recent nor so profound as to erode the other fundamental principle of international law, which has remained constant throughout, which is respect for sovereign equality. I say not so recent because the central international legal standards relied upon by the respondents and the interveners in this appeal are, in essence, the ECHR, the ICCPR, pretty much reflecting the same substantive provisions, and UNCAT. The ECHR was 1950, the ICCPR was 1966, the same year as the right of individual petition came in for UK citizens here in relation to the ECHR, and UNCAT was 1984. And so those standards have been in place for a very long time, and in particular they had been in place for a large number of years, including the developments of the jurisprudence under them.
Well, might it be said these are living instruments and therefore things develop in relation to them?
One can perfectly happily say that, but what you would have to point to is a living instrument doctrine applying to the relevant substantive provisions of those treaties, leading to a position that in effect was fundamentally different by the time you get to the key authority on this point, which is Kuwait. And Kuwait is in 2002.
But I take your point in relation to Kuwait, but in fact, I'd read this as saying what's happened is that public international law is no longer a matter of remedies just between states. It can lead to remedies between individuals and states, which of course is true of certainly 2 of those treaties and probably 3 of them, and that's the big change that's taken place.
My lady, to some extent, I can agree with that up to a point. The position, of course, is that in nature, those provisions, or at least most of those provisions, certainly under the ECHR and the ICCPR, confer on the international plane rights which are individual rights, and that is undoubtedly right. And coupled with those instruments, there has been, at least in relation to the UK and at least in relation to the ECHR, the introduction of a right of individual petition. So those rights have provided for an avenue for individuals to go there. But again, without reopening old wounds, you will be well aware that all that line of authority that considered ECHR and ICCPR on the international plane, query whether they have actually been dragged in domestically in any real sense. And we looked at those sorts of issues on Monday last week in relation to Wham Yang, you'll recall. But I think on that occasion I reminded the court that in the Queen and Lions and that line of authority, Lord Hoffman had pointed out in no uncertain terms that the only reason that ECHR rights were enforceable domestically was because their analogue had been recreated in domestic law through the Human Rights Act. So, of course, it is right that in nature, on the international plane, those instruments create rights that are in nature individual rights, but that doesn't affect their enforceability. And there is a separate point around their applicability and enforceability as a matter of domestic law. But none of those features truly developed in any real sense. And I suppose the big development was in 1998 when the Human Rights Act came into force and the analogue was created domestically. But then their nature as...
It's a bit of an oversimplification, isn't it? Because if an individual has got a remedy before an international body
yes.
under the treaty and wins before that international body, the state in question has an international law obligation to respect that remedy. So the individual does have a remedy against the state, even though it's not part of domestic law. That was true before the Human Rights Act, and insofar as in some cases there's a right of complaint to the relevant Human Rights Committee, they've got a remedy under that as well.
My lady, I don't in any shape or form seek to dissent from that proposition. The ECHR, as you know well, it's Article 41 and the role of the committee of ministers in enforcing the court's judgment under Article 46. But the point in relation to that can perhaps fairly be made is that those rights, that structure, those articles have been in the treaty and accessible. Well, they've been in the treaty since 1954 in the case of the ECHR, and they've been accessible to individuals in that sense since 1966.
Yes, well, I take that point.
The question is, what is there in international law which has expanded the jurisdiction of domestic states?
Yes.
Isn't it? I mean, I noticed there was a rather good article somewhere by the former Dame Rosalind Higgins about the role of individuals in international law. Perhaps someone could give me the reference. It's in one of the bundles, but basically she said, and I think correctly, that individuals had certain rights in international law for a long time, but it always depends on them being specifically granted it by treaty of some sort or other. And I think she said everyone should be regarded as participants. International law can impose obligations on individuals, but they don't actually have rights, usually, subject to treaties.
Yes. My Lord, I think the article you have in mind is perhaps in volume 25 at tab 202.
Thanks, yeah.
My Lord, yes, I can take all that. The real question is whether I suppose the real question in relation to 115 of the Court of Appeal's reasoning is whether that position in relation to both international and domestically enforceable individual rights, and there undoubtedly have been some developments, as we've discussed, whether any of those developments actually touches in a material way on the fundamental underlying principles of international law to do with respecting state sovereignty, and on the back of that, to do with expanding the jurisdiction of municipal courts.
Well, you would say, curiously, I suppose, the only specific example given is by reference to Lord Steyne in Kuwait.
Yes. and that didn't lead to any different outcome in terms of this principle.
So be it. Yep, thank you.
But as I say, I don't wish to be seen to be disputing the proposition that international law has developed, but it does require a bit of analysis as to what has developed, when it developed, and how that touches the principles that we're concerned with, which are the international law constraints on municipal courts exercising this sort of jurisdiction. So that's 115. 116 is perhaps close to the heart of it. It is allegations of a particularly grave kind.
Yeah.
And of course the position is that, and we don't seek to dispute the proposition, that the prohibition on torture, for example, is jus cogens. By contrast, as we point out in our response in paragraph 25, for example, the same can't be said of arbitrary detention. You can derogate from Article 5, you can derogate from Article 9 of the ICCPR, and by definition, therefore, they can't be jus cogens. But in any event, our submission is that that isn't a sufficient factor, and to some extent it might be thought that the rationale that underpin, the sovereign equality points that underpin comity and all the rest of it, that underpin the Foreign Act of State as a principle, are engaged all the more so as the allegation of seriousness or the scale of seriousness rises.
Yeah.
And our submission is that the focus should not be on the status of the international law prohibition. The relevant question is whether international law requires the civil adjudication of such issues. And it might be thought that to some extent on that issue, the relevant change in international law that is of interest to that issue is a change that involves a hardening or a clarification of the strength of the principle that sits on the other side of very grave allegations. You'll remember Jones of Saudi Arabia, Lord Bingham said, effectively this case involves a balancing by the domestic courts of the seriousness of allegations of torture on the one hand and the strength of the principle of that sovereign equality is to be respected on the other. So one has a very a powerful, as it were, hardening or clarification of the strength of the state immunity principles and of the rationale that underpin them. Jones and Saudi Arabia I've mentioned, Bundle 1, Tab 5, MS 1696. May just be worth briefly going to that. I don't think we looked at it yesterday. Can I invite you just to take that one very quickly? So Bundle 1, Tab 5, MS 1696 is the first page of it, and the relevant paragraphs for this purpose are 24 to 28.
Yes.
And you'll see in particular the reliance that is placed by Lord Bingham in 24 on the Democratic Republic of Congo, and then on the statement by Hazel Fox in the Law of State Immunity, in paragraph 24 on page 1714.
Yes, I see.
And you have a similar hardening. That case was upheld, as you will recall. And again, I haven't got time to take you to it now, but that case was upheld in Strasbourg, Jones and the UK, Bundle 10, Tab 81, MS 5102.
Thank you.
And the relevant paragraphs for the purpose of this point are 197 to 198. The Strasbourg Court concluding that an ICJ decision is an authoritative determination of the issue, and therefore following Al-Adzani.
Page 5151, yeah, thank you.
Yeah, 5151. Similar hardening we see in the ICJ. We referred to it yesterday. I think Lord Mance was referring to it yesterday, the Germany and Italy jurisdictional immunities case. Again, apologies for doing it this way, but can I give you the reference? Bundle 12, Tab 98, page 5666, paragraph 60 for this purpose, on 5722.
Thank you.
And there, effectively, they're saying that what matters is the sovereign nature of the Foreign States Act, and that legality, including jus cogens, is irrelevant to immunity. And see also para 82, the same judgment, MS 5744, where they say if the mere allegation that the state had committed such wrongful acts were to be sufficient to deprive the state of its entitlement to immunity, immunity could in effect be negated simply by skillful construction of the claim. That's what they say in 82. And there is a point about that we touched on yesterday. It leaves the application of foreign act of state, if level of gravity is the core of it, it leaves the level of gravity in effect in the hands of a given claimant and how high they're prepared to pitch the case. And as we've seen from these pleadings, in some of these cases at least, they're prepared to pitch it very high. And similarly, we looked yesterday at East Timor, but East Timor for this purpose at paragraph 29,
Yeah.
effectively saying that the alleged breach of the ergo omnes obligations had no effect on the applicability of the monetary gold principle. So we respectfully submit that if there's been any development of international law in relation to this point, allegations of a particularly grave kind, what they tend to indicate is not a greater degree of porousness in terms of the extent to which sovereign immunity and its rationale will give way to the gravity of the allegations, but if anything, a hardening the other way.
So this, you say, factors into the point made in paragraph 115.
I do. It's an aspect of the same thing,
Understand.
but it also goes directly
Yeah, understand.
to the relevance for the
Yep.
purpose of undermining the
Understand.
rationale of 116.
Understand.
And I made the point yesterday, but it is worth bearing in mind that the gravity, the point that the gravity does not touch the rationale can be illustrated by taking the detention of Rahmatullah as an example. And a major part of his claim is for false imprisonment,
Yes.
as you will recall, in respect of his 10 years of detention. And you will also recall, I'm not going to go back to the references now, but you'll recall, my lord, from the Court of Appeal in Rahmatullah, and others of you from the Supreme Court, that in the end, after the letter had been written to the US saying, will you kindly hand him back? I summarise, but it was, I'm sure, cast in more diplomatic language so as not to interfere with our conduct of foreign relations. But the response that came back didn't just say no, it said no, and we assert that his detention and his continuing detention is legal, which is perhaps as good a demonstration as one could have of the controversy that might surround both facts and law in that respect, where you have a foreign state. We know in Rahmatullah what the foreign state's attitude is going to be to that period of detention, because we have it from the Rahmatullah response. They positively assert the legality of his detention. And what you're being invited to do in the Rahmatullah claim is to opine, without them there, that's without the US there, on the correctness or otherwise of that assertion.
This is on what, the war theory, and he's a competent.
Yes, you've got the letter. Can I give you the references to the letter so you have it if you want to check on precisely what basis they were putting it? But the letter in question is in the Court of Appeal judgment. Was it quoted in the Supreme Court judgment?
Well, we can find it later.
I'll give it to you in 1 second, if you just give me one second. I'm pretty sure that Lord Kerr quoted it in his 84 of his judgment.
Yes. I think, Miss Speedy, we can find the letter rather than taking up hearing time now.
Yes,
We'll find it.
78 is the letter,
That'd be it.
84 is his conclusion that they were positively asserting the legality.
Yeah.
And of course, the court will also appreciate that there is an alternative argument in relation to gravity of the allegations, based on the need to consider whether each of the allegations
Right.
against the foreign state is sufficiently grave.
Right.
We've dealt with that in our case at
Your
170.
point is false imprisonment isn't the same as torture.
Exactly so, and neither are the economic torts and all of that.
Yep.
So, I mean, there's an obvious scale there which perhaps doesn't need to be gone through, but case 172 to 176 if you want the detail of that.
Thank you very much.
So that's 116 of the Court of Appeal. 117 can perhaps be taken together with 119,
Yep.
because this is really about accountability.
Yes.
They are both about accountability. The point at 117 is it involves UK officials whose conduct in isolation would normally be subject to investigation, and our answer to that is a short yes, but. Their conduct can't be considered in isolation. And indeed, Abbasi is an example, like Noor Khan, of a case where the conduct of UK officials would be engaged, but the English court could still not adjudicate. So if and to the extent that there is fortuitous benefit for those officials, if that's the right way of looking at it, that is a direct and necessary consequence of upholding the principle. And to some extent it links into no other forum, the point that is being made in 119.
Yeah.
But the point that we make in answer to that is that isn't so much the focus of the court's or shouldn't so much be the focus of the court's consideration we submit. The key point is rather that the English court can't be the first and primary forum. So foreign act of state doesn't preclude anyone, or indeed state of unity, going against primary actor states or their officials. It doesn't place any impediment as a principle on action against primary actors in their own states abroad, US, Thailand, Malaysia. Now, whether or not their municipal law would erect their own barriers against such an action is a different matter, but for this purpose, it's neither here nor there, because that is fundamentally a matter for their own municipal law. It doesn't support a principle that you should arrogate jurisdiction to the domestic courts. And in any event, I don't think you have a complete or even partial exposition of what the position would be were it to be relevant in those foreign states. So it is a limited principle. The question is whether English should be the first and primary forum in that way. And in those ways, accountability can be secured looking across the piece. We also know, I'm not going to trespass into controversial territory of criminal proceedings, but we know that there are ongoing investigations of that kind. So that's 119 and 117 taken together. I hope that's convenient. 118 is no lack of judicial or manageable standards. Well, 2 points in relation to that. First, that is not the sole principal basis for all the reasons I went through yesterday for foreign act of state. And secondly, there is the whole series of difficulties with trying out these claims in the absence of the foreign state that I went through yesterday, including the disconnect between a claim as of right being made and then no claim of right to drag them in by way of contribution or third-party proceedings otherwise. So that's what we say about 118. And then 120, damage to foreign relations does not outweigh the need for the English court to exercise jurisdiction. Again, there's a slightly peculiar situation on the facts in relation to that. You had evidence, or there was evidence below as is recorded by the Court of Appeal from Dr. Bristow, which they had regard to. They treated it as authoritative and as being entitled to respect, as they put it in 111. But it's at least an open question as to whether or not the sorts of points I've been making should truly or are truly dependent upon evidence, as opposed to being a matter of principled respect for sovereign equality. And I think the answer is that in terms of, if anyone's wondering why was evidence put in the first place, the answer is because the state of whether or not such evidence would be necessary was an open question, I think, below, whether it would be necessary to support concerns about the reactions of foreign state by evidence was an open question. But as the litigation has proceeded, it might be thought that the position has become rather clearer, which is that it may not be necessary to adduce such evidence, and nor should the issue properly be dependent upon that sort of evidence. It depends on it sits on the principal basis of respect for sovereign equality, which exists without the need for evidence. So that's what we say about the specific paragraphs. Can I end my submission with two very short final points, and then I'll pass over to Mr. Phillips. And they are linked. The first is that the court does need, we respectfully submit, to be at least careful about the wider consequences of that reasoning in those paragraphs. The Court of Appeal were careful in 121 of their judgment to emphasise that the factors they identified were to be treated cumulatively. But it's a little unclear how that could work, because the factors would appear to apply whenever a claimant chooses to make a serious allegation that a UK official was in some way secondarily liable with the foreign state or its officials being primarily liable.
Yep.
The second and more general point is this. It might be thought, and it's a submission we make with due deference to the power of the Court of Appeal's reasoning, but it might be thought that the first half of the Court of Appeal's reasoning, before they get to public policy and the dispositive bits that we've just looked at, is destructive of the second part. In other words, by accepting what they have accepted and by reasoning as they've reasoned up to that point, they have sown the seeds of the destruction of the public policy argument. They have accepted that the doctrine of foreign act of state is based on sovereign equality, comity, and to some extent the difficulties of decision-making. They've accepted the strong parallels with sovereign immunity and that the doctrine of foreign act of state is underpinned by essentially the same rationale. They have accepted that the principle of foreign act of state applies to sovereign acts and that those include even allegations as serious as torture on the authority of Jones and Saudi Arabia. They have accepted that they would, and the domestic courts were they to try these claims, would be required directly to rule on the facts and the legality of those sovereign acts as essential to the causes of actions pleaded.
Yep.
And yet they conclude all of those things, all of those principles, all of that basis is effectively unravelled on the basis, it might be thought, of the seriousness of the allegation and the chime into international law and accountability considerations that they deal with in the paragraphs we've just looked at. But the conclusion ultimately is not, if they are right in their reasoning in those paragraphs, is not that public policy in this sort of sphere operates as a limitation on the principle. On the Court of Appeal's reasoning, which is why I say the seeds of their own destruction were sown in the first part of the judgment, on the Court of Appeal's reasoning, the public policy application, if it works on those principles, operates not as a principle of limitation, but as a principle of destruction. It operates in effect to destroy foreign act of state as a principle, or very, very significantly to undermine it. My lords, my lady, those are my submissions, unless I can seek to assist further.
Thank you very much, Mr. Quigley. Thank you. Mr. Phillips.
Lords and Ladies, state immunity. Sovereign immunity is a rule of customary international law which operates as a procedural bar to prevent domestic courts from exercising jurisdiction which they would otherwise enjoy. And like foreign act of state, as my learned friend has observed, it's founded on the concept of the sovereign equality of states and is also consonant with considerations both of public policy and of comity.
Yeah.
And the Court of Appeal pointed out in Belhaj at paragraph 48, that's MS 354, that the two doctrines share those common rationales. Sovereign equality is at their heart. And the core principle is the same. One state may not adjudicate on the official acts of another sovereign state without its consent. That's Lord Bingham, paragraph 1 at Jones, volume 1, tab 5 at MS 1704. But this principle, that of sovereign equality, has a significant place and role internationally, as the International Court of Justice noted in the Italy-Germany, the jurisdictional immunities case, paragraph 57, at MS 5718, in which the court said that the doctrine, and I quote, occupies an important place in international law and international relations. As you know, in this jurisdiction, the rule and the exceptions to it are set out in the 1978 Act, which itself implemented the European Convention of 1972. And subject to the exceptions, immunity must be granted in respect of all acts attributable to foreign states and performed in the exercise of their sovereign power outside the UK. So the focus, so far as we're concerned, is on the nature of the acts themselves. Do they fall to be characterized as de jure imperii? That assessment, as my learned friend Mr. Eades pointed out, has nothing to do with the lawfulness of the acts. That's Jones, and again, the jurisdictional immunities case concerning crimes against humanity. And Lord, that, by way of introduction, enables me to identify the relatively narrow scope of issues between the parties on this appeal. Here, there's no dispute, nor could there be, that the acts alleged are paradigm sovereign acts, relating as they do to defence, national security, and foreign relations. It could not be suggested, and is not suggested, that they fall within any of the relevant exceptions in the Act. Nor is any attempt made to say that the gravity of the allegations takes them out of the scope of immunity. That's the Jones and immunities point. Nor, finally, is it suggested that any of the relevant acts took place in the United Kingdom. As my learned friend has told you, all the relevant allegations took place elsewhere. And it follows, for example, that Section 5 of the Act, which concerns personal injury claims where the acts took place in the United Kingdom, does not apply. And all of that means that it's not an issue, finally, that if the foreign sovereign states were sued, they would be, or their officials, they would be entitled to immunity under Section 1 of the Act. But of course, as the learned friend has outlined, they haven't been, and so we find ourselves on this side of the fence as well in the same procedural tangle as is the case when one's looking at the thing through the perspective of foreign act of state. If the Court of Appeal and Mr. Justice Leggett are right, the actions will proceed with the various primary actors absent. And in Belhaj, for example, that means that the alleged co-conspirators, the United States and Libya, would take no part, unless, of course, they decided to consent to the jurisdiction of the English court and to defend the serious allegations against them. And that would put them in precisely the position which the rule is intended to avoid, namely where a state is forced to choose between defending itself or its interests on the one hand, or preserving its sovereign equality with the foreign state on the other. Because, of course, by consenting, the state submits. That's the procedural word we use, submits to jurisdiction. And at that point, there is no equality between the foreign state and the forum state. And that's why we say that in relation to sovereign immunity also, the respondents seek to obtain by the back door what they could not obtain by the front. Or to put it another way, we say on these pleadings that the foreign states are indispensable third parties to the trial of the allegations made. The actions cannot proceed, we submit, without breach of their sovereign immunity. And in those circumstances, our submission is that the states have been indirectly impleaded for the following brief reasons. One, as I've submitted, the lawfulness of their acts forms the central subject matter of the claims. Findings in relation to those matters are a necessary prerequisite. Two, if they'd been named as defendants and sued, they could have claimed sovereign immunity. And indeed, of course, even if they had not done so, the court would have been obliged, Section 1(2) of the Act, to take the point. And for that reason, a point I should just note in passing made by the respondents to the effect that the foreign states have not, in these cases, communicated any claim to immunity is nothing to the issue. It is for the court to take the point in any event. Third point, a judgment with findings of this kind inevitably and seriously affects the interests and activities of the foreign states. In substance, we say that there's little, if any, difference between a finding that a state has acted unlawfully and a formal declaration to that effect in proceedings to which the state is a party. I'll return to that in looking both at the convention, the 2004 convention, and at the domestic authorities. But we submit the key here is to take a realistic and not a technical approach. The example I'd like to give, but I'm not going to take you to it with my eye on the clock, is Nur Khan. And there, if you remember, that's Authorities 3, tab 23, yep. Lord Dyson draws a distinction between what he refers to as the strict legal analysis, that's paragraph 35, MS 2340, and the reality of the situation, and that's his paragraphs 36 and 37. And we do submit that these cases are at least as strong as this because of the point about the necessary findings as a preliminary. And that, as we say, is the reality about these cases. They cannot be described as requiring merely findings of fact. That's the Kirkpatrick point. So, Lord, may I turn to the topic of indirect impleading itself? Yes. And I should say that I'm going to try and finish my submission shortly after 12 so that my learned friend and I can, as it were, complete all our submissions before lunchtime. Because
well, you should do so well before lunchtime.
Well,
you've had extra time already.
Lord, I'll be taking it as quickly as I can.
I understand that. Thank you.
Lord, and I won't be, I hope, repeating what's in writing. Everybody's gone into writing at great length, and I won't necessarily be addressing every single point. I'll be proceeding.
But we will assume that everything you've said in your written case
Great.
you adhere to. We won't treat you as having abandoned it if you don't refer to it. Thank you.
Lord, so far as indirect impleading is concerned, as the Court of Appeal acknowledged, paragraph 35, MS 348, the common law recognised the concept of indirect impleading, and the rationale for it is entirely understandable. It may be just as inappropriate for the courts of the forum state to rule on issues where the foreign state is indirectly impleaded as it is when it's directly impleaded. And we submit that whether that is so in any particular case falls to be tested in the same way, namely by reference to the rationale which underpins the doctrine. And that means, in turn, looking at the impact of the findings which the court is being asked to make on the interests of the state. And that's also why, in agreement with the Court of Appeal in Belhaj, we submit that the concept of indirect impleader is not restricted to property cases. The Court of Appeal, we submit correctly, recognised that there were other cases of high authority in which the doctrine had been applied which did not involve state property. Jones is the most recent and most prominent example on which we place reliance.
But it is a case, Jones, where, in international law at any rate, the state would be responsible in damages, even though the act was outside the scope of the authority of the agent or employee.
Lord, exactly. And I'd like to take you to Jones in a moment, but the key to it is Lord Bingham's analysis of attributability, a difficult word to say, in the context of international law. Yes. And that is precisely, as we'll see, the foundation for his decision in that case.
I presume, is the rationale of the property bar the same, that actually the title to the property would be affected? Of course, that would lead to the somewhat paradoxical situation that you could adjudicate upon the right to property which was outside the jurisdiction because you wouldn't be affecting the title.
Well, Lord, if I may, I'll come to the property cases in a moment, but what we say about them is that when you analyse the common law cases, i.e. the cases before the Act, because there's now, as your Lordship appreciates, an exception in the Act, yes. Section 6, specifically for property cases.
Yes. Where do we find, forgive me, Mr. Phillips, where in the voluminous authorities that we have been presented with do we find the Act?
Lady, of course I should have taken it to you. It's at Authorities 1, tab 10, MS 1810.
So it is.
I suppose I'm wrong in the property case. It would only be a binding decision if the state submitted.
Well, that's exactly the point, Lord. In an indirect impleading case, one shouldn't be surprised to discover that the effects are indirect. Lord, as we'll see when we look at...
It would only be, only if the state submitted all the property was within the jurisdiction, if you were suing the property as a ship. I mean, the most of the cases are about ships, aren't they?
Well, my Lord, no, some of them are in fact about gold, as we'll see.
Dolphus, yes.
Dolphus Meek, exactly.
Yes.
Lord, may I return to that in the context of Jones?
Yep.
Our position in relation to the property cases, my Lord, is simple, that the rationale, when followed through, does not justify the restriction of the indirect impleader cases to property, because precisely, and this is our case at paragraph 57, 58, it would be inconsistent with that rationale to so limit it and to exclude the paradigm sovereign acts which are an issue in a case like this. Because in the spectrum of such acts, it cannot be denied, we submit, that these sorts of acts lie much closer to the heart of the doctrine than the property interests, which, if anything, are more likely to be found nearer the edges of the spectrum and are now, as I say, dealt with in any event by an exception in Section 6. Lord, what my learned friends in their case say about this, and I'm going to simply give you the references, paragraph 35 first in MS 188, is first to seek to rely on section 6.4 of the Act, that's MS 1814, in order to suggest that in some way that subsection represents the full extent and limit of the indirect impleading doctrine under the Act. Well, my Lord, that cannot be right, we say, because if one looks at section 6, it deals first with exceptions, and 4, subsection 4, beneath B, identifies, as it were, a reverse indirect impleading category within that exception, in the sense that it deals with a case brought against someone other than the state in respect of state property where, and these are the crucial words, the state would not have been immune had the proceedings been brought against it. So that, we say, is of no assistance to my learned friends. Nor can it be suggested that this subsection is intended to cover or limit or define the entire concept of indirect impleading. And that is not what the Court of Appeal in Belhaj thought, and the reference there, my Lord, is paragraph 35 of the judgment at MS 348, and indeed at 36, where, of course, they did acknowledge a further category of indirect impleading which had nothing to do with property, namely Jones. Again, reliance is placed by the respondents, paragraph 37 of their case, MS 188, on holdings by Mr. Justice Leggett, holdings which find no place in the Court of Appeal's analysis, as to two alternative rationales for the indirect impleading cases. That's paragraph 55 of his judgment, MS 971. We respectfully say that those rationales may indeed explain why property cases are covered, but they provide no basis at all for confining them or confining indirect impleading to cases of this kind. Lord, this is an example where Mr. Justice Leggett has taken a different approach to the Court of Appeal, as he did very much so in Foreign Act of State, because, as I've said, the Court of Appeal acknowledged the existence of the Jones non-property indirect impleading category. Lord, may I now ask you to turn up Jones briefly?
Yes, of course.
I know we've looked at it before. It's at Volume 1, Tab 5, MS 1696. There were, as your lordships, my lady will remember, two actions. Central allegations concerned torture. The first action was against Saudi Arabian officials. The second was against various officials only. The judgment of Lord Bingham sets out the two principles. You've seen this, paragraph 1 at 1704. The course of the proceedings at 2 and 3. The Court of Appeal's judgment, including, of course, my Lord Mance at paragraph 6. And then at paragraph 7, how the concept of state immunity had developed, the Act marking a relaxation of the principle, that's paragraph 8 on 1706. Note, please, at D of this page, the reference to the 2004 convention by Lord Bingham, and there his approval of a comment by Mr. Justice Aikins in the AIG case about the convention, its existence and adoption by the UN after long and careful work of the International Law Commission and the UN Ad Hoc Committee, powerfully demonstrates international thinking on the point. Then reading on to 10, Lord Bingham notes that the Act does not address specifically the role of officials, moving on to page 1707. And making it clear there, we say, that the concept of indirect impleading, quoting the relevant article from the Convention just between D and E, is not confined to property cases, and that's the same position that the Court of Appeal accepted. But then, perhaps importantly, in terms of the decision, paragraph 12, and this is the point Lord Mance raised in relation to international responsibility. I'm going to use that expression, but the term throughout concerns attribution.
Yep.
And then, passing briefly over the paragraphs that my learned friends showed you, to paragraphs 29 to 31 at 1716,
Yeah.
these, so far as I'm concerned, are the key paragraphs in which he explained why he was departing from the decision of the Court of Appeal in relation to the officials. And the key paragraph is 31. And just above G, it is, however, clear that a civil action against individual torturers based on acts of official torture, that being one of the arguments in the case, does directly impede the state since their acts are attributable to it. Were these claims against the individual defendants to proceed and be upheld, the interests of the kingdom would be obviously affected, even though it is not a named party. And Lord, it's worth noting at the end of his speech, paragraph 35, the next page, 1717, that he says that he also agrees with the speech of Lord Hoffman. And we accept, and have done so in our case, that Lord Hoffman got to the same answer by a different route. And Lord, you can see, in a sense, the key paragraph for Lord Hoffman at 69, 1725, which was based on a construction of the use of the term state in section 14.1b. And then just turning to the end of the judgment, 102 and following at 1732, you'll see that Lord Hoffman agrees with Lord Bingham, and the other three judges agree with both of them. Now, Lord, dealing with this as quickly as I can, we say in respectful agreement with the Court of Appeal in Belhaj that this is a non-property, indirect impleading case. And the fact that Lord Hoffman, with respect, agreed with Lord Bingham, but also found his own route, is nothing to the point. Mr. Justice Leggett took the view that this was in truth a direct impleading case, and we say, not least on the reasoning of Lord Bingham and of the Court of Appeal in Belhaj, that he was wrong, even if that conclusion was open to him. However, as you will have seen, this is now an argument advanced by the respondents. And we simply say that when one looks at the reasoning of Lord Bingham, with which their lordships agreed, that it's plain that he regarded it as a case of indirect impleading because of the state's responsibility in international law for the acts or actions of its officials. Now, my Lord, we do say that that case is strongly supportive of our position because, although, of course, we acknowledge the factual distinction, namely that the officials, if I can put it that way, have not been joined in these cases, the practical effects are indistinguishable. And I'm not going to go over it, but we've set that out in paragraphs 67 to 69 of our case at MS 118 to 119. From which one can see in my submission that the factual distinction is only relevant to the potential domestic liability of the officials. Makes no difference at all to the state whose immunity it is. Any unlawful acts which the court finds that officials of the foreign states have committed are attributable to those states as a matter of international law. And we say with respect that in their case the respondents have not sought to grapple with the Court of Appeal's analysis of Jones, with Lord Bingham's reasoning, or indeed with the submissions we made in our case, paragraphs 64 to 71, MS 117 to 120.
Right.
My Lord, it may be that Mr. Justice Leggett's view of attributability was coloured, and indeed his view of Jones, by his point, judgment paragraph 63, MS 973, that the acts of UK officials are not attributable to the US. Well, of course, with respect, that's true, but it is also, we say, irrelevant. In both of these cases, the key question concerns the responsibility of the foreign states for the act of the foreign officials whose acts are at the heart of both claims. And it's for that reason that we say that the case that we make, the strikeout that we have launched, is not an attempt to say that the UK is entitled to any form of sovereign immunity. We accept that cases can be brought in this country against the appellants.
Yeah.
My Lord, that is why, for example, the issues in Rahmatullah are confined to those concerning US detention. There's no attempt to strike out the direct allegations against UK officials or the UK bodies. And the same is true in Belhaj, where, as you may remember, the point is made that only some of the allegations are sought to be struck out. The direct claims are not impugned in this application.
But can I come to the basic point you're making is that there's indirect pleading just as much in this case as in a case where either the state or its officials were joined.
Yes.
But depends what you mean by impleading. Surely impleading postulates that as a result of the proceedings, someone will be held liable. And all Jones suggests is that it doesn't matter whether you're holding the state or its officers liable, because the officer's liability will be attributable to the state. Now, if in the present proceedings you succeed, or the other side were to succeed in getting a finding of unlawful conduct on the part of the Malaysian authorities, say, or the Thai authorities, or the Libyan authorities, that wouldn't bind them. It wouldn't be against them, it wouldn't be against officials who would bind them. It would just be res inter alias acta.
Oh, Lord, by definition, indirect impleadings are concerned with indirect effects. But as Lord Bingham pointed out in Jones, if the proceedings were allowed to continue, the acts of the officials would be attributed to the state. And the same is true here. That's not as a matter of domestic law.
You're not grappling with the question, or which I'm really seeking to put, namely, is there any basis, either in domestic law or in international law, upon which Malaysia, Thailand, etc., would be bound either directly or indirectly as a result of the proceedings, present proceedings, if they went ahead?
Well, my Lord, with great respect, the test we submit is not whether they were bound. That might be appropriate to a direct impleading case by definition. The test is whether their interests are affected. That's the expression used by Lord Bingham.
I mean, nobody likes having witnesses, and no doubt don't like having findings made about them, and third parties sometimes suffer that fate. But there is a distinction between being legally bound and not being legally bound, and in case of state immunity, on the face of it, it's dealing with situations, isn't it, where proceedings are actually against someone or against someone for whom the state is vicariously liable, or against property, which the legal title to which will actually be affected will be bound by the result of the proceedings.
Well, my Lord, as we'll see, I do want to take you to Dolphus Mead. In fact, what the cases show is that indirect effect is enough. And, my Lord, it is no question of binding comes up. The question is, would the interests of the state be affected indirectly?
Yes, I mean, I see that point. That's your case. But on that argument, state immunity takes over a considerable body of the area where foreign acts of state would otherwise operate.
Well, Lord, I'm not going to try and sort of draw fine distinctions between them. We shouldn't be surprised by the overlap. is my simple answer to that, because the doctrines share common rationales. And indeed, if one looks at the authorities, it's perfectly clear that judges are often using the terminology that we would associate with both or either or in the course of their reasoning. The same is true in Boots, for example.
But
So, my Lord,
does would be obviously affected mean affected in some general way, or does it mean affected as a matter of law?
my Lord, I do want to show you the convention and the
Right.
wide terms of it.
Well, that seems to me to be the issue in a
Yes.
sense.
Well, my Lord,
So you want to take us to the material, yeah.
yes.
Speaking for myself, I think that rather than talk in terms of would they be bound or what's the legal effect, the best word, the most helpful word that I can think of at the moment is consequences. What would be the consequences for the foreign state of these findings that the claimants seek?
Well, my Lord, we do say, as I've submitted, that if findings of unlawful acts of this kind were made in the course of this litigation, there would undoubtedly be effects. The claimants seek declarations here. They seek declarations as to illegality. They seek
Declarations
in that way,
against the defendants.
yes, my Lord, but they can only be made, the way the pleading is put, it's paragraphs 1 and 101 in Belhaj, they can only be made if the unlawful acts, which, as we know, primarily concern the foreign states, are made out. So, my Lord, the court may not identify in the declaration state X or Y, but the effect is still the same, as if the foreign states were there and having these findings of unlawful conduct. That's what we're talking about. These are, we submit, indispensable third parties to this litigation. It's just they won't be there. Lord, can I take you to the convention?
When you say that there doesn't have to be any interest of a legal nature at all.
Well, Lord, I'm not saying that. There has to. I'm sorry. I'm not saying that there has to. I am accepting that there has to be a legal effect, but it can be, if one looks at the convention and looks at some of the domestic cases, on a range of interests and activities. That's what the 2004 convention
What is the legal
says.
effect in this case of a finding, if the proceedings went and the findings sought by the claimants
Well,
were upheld? What is the legal effect on any foreign state?
well, my Lord, the fact that a state in another jurisdiction had declared that officials of the relevant foreign state had been guilty of these torts, of these very serious matters, would undoubtedly something which would affect.
What would be the legal effect?
Well, my Lord, it may be that it's something that could be sought to be relied upon in proceedings under UNCAT or possibly in relation to the criminal jurisdiction that we're all so keen to not get into. But, my Lord, we do say that where a party seeks a declaration, he is seeking to shape the future conduct of a state.
Surely it's not legal effect, it's a legal interest. And the relevant legal interest would have to be the legal interest of a state simply in not having the appropriateness of its sovereign acts questioned in a state which is equal to it.
Well, my Lord, that is absolutely
But that's not
true.
a legal effect. It's a legal interest in the immunity itself, which only arises if you it only arises if the subject matter is of the domestic litigation is the culpability of the state.
Well, Lord, I think the best thing may be to take your lordships to an example of a domestic case of indirect pleading,
You
which
take
the
us to
learned
that.
friends rely on, to see what sort of effect is actually required.
Okay,
And, Lord, that's at that's the Dolphus Mead case, and it's at 9 tab 66.
Could you, in passing, I think you did give us a reference before, could you give us a reference, or me the reference, to the declarations actually being sought?
Yes. I can certainly start with Belhaj, and that's in the core volume number 2, paragraph 1, MS 512, and MS 541, that's paragraph 101.
Thank you.
Perhaps
512 and
541, I think I said, Lord. Yes, 541.
Thank you. Yep, Dolphus.
Dolphus Meag at tab 66, volume 9, that's MS 4415. Lord, this is another, like monetary gold, this is another post-war case concerning gold. The plaintiff brought a claim to recover 64 gold bars that it claimed as its property. The claim was not brought against any foreign states, but against the Bank of England, a legal person within the English court's jurisdiction. The gold bars, as you can see from the speech of Lord Jowett at 598, that's MS 4431,
Yep.
had been deposited with the Bank of England by the Treasury, and in doing that, the Treasury had acted on behalf of 3 states, the UK and the US and France. The Bank of England was therefore bailee for all 3 states. And Lord, you can see that at 599 MS 4432 at the bottom. Now, what happened originally is the plaintiffs, as I say, sued the Bank of England. After the first instance judgment, it emerged that the Bank of England had unfortunately sold 13 of the bars by mistake, but retained 51. Lord, that's 583 at 4416, at which point the proceedings took a new course. Foreign states applied to join on the immunity points and applied for a stay. The result was that the House of Lords stayed the action brought by Dolphus Meag against the Bank of England in respect of the 51 bars that the bank still had. So, Lord, neither the Bank of England nor the UK had a right to state immunity. But the claim against the bank, and, of course, indirectly in that sense against the UK, was stayed because of the immunity of the United States and France. So, in my submission, the case tells us a good deal about what sort of legal effect is necessary in an indirect impleading case. The first point to hoist in at 6134416 is that the plaintiff, this is the speech of Lord Porter, the plaintiff was prepared to seek the monetary value of the bars by way of damages for conversion from the bank rather than the bars itself. And so the question arises, how then did the claim indirectly implead both foreign sovereign states? They weren't directly affected by the claim for damages at all. If the Bank of England lost, it would be liable to pay those damages to Dolphus Meag. But the United States and France were indirectly affected because if the Bank of England had to pay damages to Dolphus Meag, the Bank of England would then potentially be in a position to contest the right of the 2 sovereign states to the gold bars. Now, my Lord, one can see that reasoning at 6074440 in Lord Jowett. In the first or second full paragraph beginning, it remains.
Remains to be considered, yeah.
Yes. And to similar effect, Lord Porter at 6134446 and Lord Tucker at 6224455. And that passage is worth looking at because there Lord Tucker acknowledges that the idea that the bank might take such an action was highly improbable. But that made no difference. The interests of the US and France were sufficiently affected by Dolphus Meag's claim against the Bank of England for state immunity to imply by way of indirect impleading. And as we say, that is true here. The foreign states are not directly affected, but in a sense that's the essence of indirect impleading. And here what my learned friend, Mr. Eady, submitted about the procedural complications is also relevant, because the actions, if they proceed, give rise to the possibility that these appellants could, and again, may seem very unlikely, seek an indemnity or contribution from the foreign states with whom they are alleged to be jointly liable. As I say, it's highly improbable that any such claim should be made, but that wasn't the answer, or not a bar, in Dolphus Meag. State immunity didn't fall away in that sense. And whether one looks at it that way, or whether one looks at it as learned friend did, by reference to the Civil Liability Contribution Act, we say that the necessary indirect effect here is made up. So, my Lord, when one looks at the domestic cases on indirect impleading, then, one sees that they go as far as to cover a case like that. Lord, my next main point, as you know, is on the Convention. I'd like to turn to that now. It's Volume 1, Tab 6, at MS 1733. And again, there's been a great deal written on this in the cases. I'm not going to go over that. But our position, as you see, is simple. State immunity is a rule of international law. The Convention represents, as Lord Bingham said, an authoritative statement of international law, and has been so regarded in the domestic courts. And for the reasons we set out at paragraph 60 to 63 of our case, MS 116 to 117, and 72 to 77, MS 120 to 122, the relevant provision here, Article 6.2b, which I want to show you now, reflects customary international law. But in any event, we say that given the origin and status of the Convention, it gives authoritative guidance on the scope of indirect impleading. So, my Lord...
But why then has it not been ratified or come into force?
Well, my
Is
Lord,
it
that...
simply unnecessary?
No, my Lord, no, my Lady, I'm certainly not saying that. I do, however, draw to your attention that in the international jurisdiction case, Germany against Italy, the International Court stressed the importance of the Convention as an authoritative summary of principles of international law on this point. And in that case, my Lady, neither Germany nor Italy had ratified the Convention. So it didn't, with great respect, make any difference, and in my submission, shouldn't here.
I'd still like to know the answer.
So, my Lord?
I'd still like to know the answer.
Lady, I don't know...
Why has the UK not ratified it, and why has it not come into force?
You say Germany and Italy haven't ratified it either.
No, my Lady, I think I'm right in saying that 16 states have ratified.
That's not enough.
Well, my Lord, this is dealt with by the Court of Appeal, exactly, my Lady.
Did you say that the Convention reflected customary international law?
Yes,
Phillips?
You did say that.
You remember that the UN interveners say that their Convention doesn't reflect customary international law?
Yes.
Well, can we get to the bottom of that? Or
well, Lord,
what should we read in order to get to the bottom of it?
What we've done is to set out in our case, and can I just give you the references?
Thank you.
The material we rely on, academic material and case law, and that is, Lord, at 60 to 63, MS 116 to 117, and then MS 120 to 122, that's paragraph 72 to 77. And we've also addressed the matter in our response in dealing with the comparative law points. That is, at paragraphs 48 to 55, and that's MS page numbers 11,500 to 11,501. Now, my Lord, so far then as the Convention is concerned, as Lord Bingham noted in Jones, the concept of indirect impleading is recognised and defined in it. You'll see the relevant articles. First, Article 5, State Immunity, setting out the basic position. 6.1, Modalities for giving effect. First of all, has a similar principle to that in our statute at 1.2. The court should give effect to it of its own motion.
Yep.
2A and then 2B deal with first direct and then indirect impleading.
Yes.
And the phrase is not named as a party to the proceedings, but the proceeding in effect seeks to affect the property, rights, interests, or activities of that other state. Then, Lord, the first point to note, and it's a point the Court of Appeal accepted, paragraph 45 at MS 352 to 353, is that it is not confined to property. And the contrast there is with Article 13, which you'll find at 1738. It's clear, therefore, that when the parties intended to confine a provision to property, they did so expressly, and that's not the case here. Nor can it, we say, have been intended to cover the situation where the agents or officials of the state have been sued, for the state is defined here at Article 2(1)(b)(4) at 1734. This also the Court of Appeal accepted, holding that the purpose of Article 6(2)(b) cannot, therefore, be to extend immunity to proceedings in which officials are sued. And, Lord Milady, that is paragraph 46 at MS 353. And it must follow, we submit, that the Convention's wide terms envisages indirect impleading cases in which officials are not sued and which do not concern property. And that's where we rely on the academic writings, case paragraph 61 to 62. Now, the result of the Court of Appeal's construction of the Convention and their approach to the two categories of indirect impleading in domestic law is that the Court of Appeal were consciously drawing a line in a different place to that we say they acknowledged pertained under the terms of the Convention. And our simple answer on that is that we say there is no warrant for it, and again, the reasons are set out in our case. What then did the Court of Appeal make of the Convention? And, Lord, this is the second ground of our appeal, paragraph 85 of the case. They reached no express conclusion, in fact, on whether the Belhaj claim fell within the scope of Article 6(2)(b), but appear to have suggested that a rather limited interpretation of the relevant part of it should be given, namely, and this is again paragraph 45, so as to confine it to legal interests as opposed to interests in some more general sense. And you'll have seen that Mr. Justice Leggett also used the term legal effect in trying to cut down its scope, paragraph 74 of his judgment, MS 975. But in our submission, these readings fail to give any meaning to the word activities, contrary to the well-known canons of treaty interpretation, and impermissibly confine the meaning of interests and activities to legal interests, for which we respectfully say there is equally no warrant. And in their case, the respondents have also sought to confine the meaning of the words. For example, in paragraph 46, they say that Article 6(2)(b) is concerned with proceedings whose effect will be to impose some, and I quote, direct, real and binding consequence on a foreign state. It is, in my respectful submission, impossible to conjure that meaning from the broad words of the Convention, not least the phrase, not named as a party to the proceeding, but the proceeding in effect seeks to effect. And so this, we submit, is an example, one of a number, of the respondents in their case paying lip service to the concept of indirect impleading, but in effect seeking to render it meaningless. Where a claim is brought against a foreign state's officials, we say, the effect on the foreign state as a matter of domestic law is not direct or binding, but it is most certainly real, and that takes me back to Jones. And that is also true of the effect on the foreign state's interest in, for example, the property cases. And that's where I cite and rely on the indirect effect in Dolphus Meag. Lord, of course, the Court of Appeal found that even if the article does have the wider meaning or effect for which we contend, and that's paragraph 47 of the judgment at MS 354, it cannot be considered to be reflective of the rule of customary international law. And you have our written submissions on that, which I've given you the references for. But even if that's right, we say that it cannot seriously be doubted that the Convention as a whole is regarded domestically as an authoritative statement of international law. That's precisely what Lord Bingham said in Jones. And we, of course, rely, as I've already mentioned, on the jurisdictional immunities case in paragraphs 89 and 55, the references being MS 5748, 5749, and 5716 to 5717.
89 and 95, was it? 89 and what?
89 and 95, yes. I'm sorry.
No, that's fine.
I think when you look at them, you'll see why I've given them in that order, Lord. Lord, the final point on the international law claim we make, it concerns monetary gold. And again, I'm aware that my learned friend Mr. Eadie's been over this, but the concept, we say, which is set out in monetary gold, reflects what is said in that case, and the courts below fail to acknowledge the importance of the monetary gold principle as an analogy to the rule of state immunity. And Lord, so far as monetary gold is concerned, you'll remember again that's another gold case. This case involved the question, who owned the gold? Was it Italy or Albania? The Allied powers, again, France, the United Kingdom, and the USA, agreed to be defendants to be claims in the international court made by either Italy or Albania, or both, if they chose to make them. As to the legal question as to which country should receive the gold, in fact, the contenders were the United Kingdom and Italy, because, although an arbitrator had determined that the gold belonged to the Albanians, because the UK claimed to be entitled to it in partial satisfaction of another decision of the ICJ in the Corfu Channel case. The position before the International Court was that Albania made no claim. Italy did make a claim, but then challenged the jurisdiction of the court. And Lord, the references there are at the bottom of page 28 of the report, 7274, and that in turn led the UK to contend, page 29, 7276, that Italy's position was fatal to her application under the agreement which had set the whole thing up. The court disposed of that, that's the middle of page 30, and turned to the application which Italy had made. And the key question, page 31 of the report, was whether the jurisdiction conferred on the court was coextensive with the task entrusted to it. I should have said, my lady, the reference is 16114 to this report. And the key, in fact, may I just ask you briefly to take that up, 16114, to see the relevant passage, which on page 32 of the report.
Which volume?
16 and tab 114.
16.
Tab 16.
Oh, what's
Bundle
the MS
16.
number?
Tab 114.
The MS number is 7256.
I
And
thought
the-
16114 was the MS number.
So did I, and I found even this bundle doesn't go as far
No,
as that.
lady, I'm pleased to say we come in under 16,000.
So far.
The MS number for the relevant page is 7282.
Thank you. Yep.
And you'll see the relevant passages, the first, second full paragraph, the court cannot decide without the consent of Albania. It has not contended by any party that Albania has given her consent. To adjudicate upon the international responsibility of Albania without her consent would run counter to a well-established principle of international law embodied in the court's statute, namely that the court can only exercise jurisdiction over a state with its consent. And then at the bottom of this page, Albania has not submitted a request to the court to be permitted to intervene. In the present case, Albania's legal interests would not only be affected by a decision, but would form the very subject matter of the decision. In such a case, the statute cannot be regarded by implication as authorizing proceedings to be continued in the absence of Albania. And you'll see later the court deals with Article 59, which is the article my learned friend Mr. Eady has already referred to, which deals with binding or not effect, and says that's not the answer. Now, as Mr. Eady has said, that's been more recently articulated in the East Timor case, and the respondents accept in their case, this is paragraph 69, MS 201 to 202, that the principle is in effect the same concept as common law indirect impleading. And the key underpinning, we say, that applies in both of these cases is that the court would be required as a prerequisite to rule on the lawfulness of the absent state's acts or conduct. And that, of course, takes us back to the allegations and the position we say in this case.
Did it make a difference in this case that the sole relevance of the existence of the alleged international wrong committed by Albania against Italy, its sole relevance was to the right to take possession of gold bars which were in fact the property of Albania, so that it comes directly within what in English law we would call the property extension?
Well, Lord, it's still, with great respect, a useful analogy because that very issue was a prerequisite to the court's simple determination of the issues. In other words, without it, the court concluded it could not proceed to determine the issue. Now, what the issue was, in a sense, from the point of view of the analogy I seek to draw here, is neither here nor there. The principle remains the same.
Well, is that right? Because everybody here accepts that there is no substantial difference between proceedings which seek to claim rights over property, like an action in rem, and proceedings against the owner of that property. Now, that's a relatively limited extension. If the monetary gold exception is really only concerned with rights to gold bars, then it doesn't necessarily go further than the limited exception for property.
Well, Lord,
I mean, East Timor may well be a better case for
Lord, I think it is. And the reason it is because what monetary gold sets out is a much wider principle, which, as you rightly say, if I may say so, has more relevant application when we come to the facts of East Timor, but the fundamental principle remains the same. Lord, so far as
Yep.
concluding submissions are concerned, what we say, as I've submitted, is that as in the monetary gold East Timor case, so here, these foreign sovereign states are indispensable parties to the litigation. It cannot be brought without breaching their sovereign immunity. And the cases in this appeal are clearly, we say, on the right side of the line. We are not saying that the doctrine applies every time the acts of a foreign state require some examination or might be criticised. That's not our position, and not these cases, which, as the courts below have found, involve prior findings of unlawful conduct on the part of foreign states. Nor do we suggest that immunity applies where there's no possibility of any legal effect on the state or its property. But we do say, following Dolphus Meag, that the effect may be indirect. We do not seek blanket immunity, as learned friends would suggest. We simply say that whereas here the foreign states are fairly characterized as indispensable to the resolution of the issues, the doctrine applies. And Lord, there's one other point I've been asked to deal with. In answer to the lady's question, my instructions are that the United Kingdom has not ratified the Convention, as some of its provisions, for example, Article 12, and we do 11, we do refer to that in our case at paragraph 72, in the context, I think, of Benkabush, decision of the Court of Appeal, which I think is on its way here.
Yep.
Some of the provisions are controversial, but so far as the United Kingdom is concerned, you won't be surprised to hear Article 6.2b is not. Lord, unless there's any other matter, those are my submissions.
Thank you very much indeed, Mr. Phillips. Thank you.
Yeah.
Mr. Levy.
There's a light diversion into Article 6. You know well the shape of the Article 6 issues. We're in that line of case law, or potentially we're in that line of case law that seeks to determine when something operates as a procedural bar and when something operates as a substantive limitation on the domestic legal right. The Article 6 analysis breaks down into two stages. The first question is whether or not Article 6 is applicable at all, and it is to that question that that distinction between procedural and substantive goes. And the second question under Article 6, assuming engagement, is whether or not such restriction on access to court as exists is a justifiable one. If I can start the wrong way round, at least to show you the shape of the issues, so far as justification is concerned on state immunity, and obviously one's got to be considering both state immunity here and foreign act of state. So far as state immunity is concerned, if you reach the stage of justification, my submission is that Al-Adzani in Strasbourg provides you with the clearest possible answer to justification.
Yep.
If you reach the stage of justification in relation to foreign act of state, my submission is that the logic and reasoning of the Court of Appeal in the Belhaj case, where they dealt with this matter in a single paragraph at 123 of their judgment, para 123 of their judgment, the logic of that paragraph is conclusive in our favour. That's a slightly odd submission to make, given the punchline, which was to find against us. But you will understand, I hope, why I make it, because the logic of the Court of Appeal's reasoning was to, in effect, accept that foreign act of state pursued a legitimate aim and that it was a justifiable principle, even though it might be of less limited application than state immunity as a concept of international law, but nevertheless to conclude that it couldn't be justified under Article 6, essentially for the reasons that I went through at the conclusion of my submissions. In other words, the 6 factors that I ended my opening submissions on. That's the structure of the reasoning. So if the answer is that you conclude that foreign act of state applies and that those reasons don't work, the logic of 1, 2, 3 works for me. That's essentially where we go. There is one could spend days and certainly hours exploring all the set of issues about applicability. But I'm going to deal with it much more crisply than that, if I may. In relation to state immunity, first, so we're on state immunity engagement of Article 6. There is a straightforward compulsion of the reasoning boxing match. In the blue corner, you have Lord Millet in Holland and Lamp and Wolf, supported by Lord Bingham in Jones and the Kingdom of Saudi Arabia, describing Lord Millet's reasoning in Holland and Lamp and Wolf as persuasive. That's paragraph 14 of Lord Bingham in Jones. And Lord Hoffman, paragraph 64, indicating that he would be inclined to agree with Lord Millet's reasoning. Also supported by the Court of Appeal in Benkabush, paragraph 16. The compelling word is used again. Also by the Court of Appeal in Belhaj, para 122 for this purpose, and by Mr. Justice Leggett for good measure in Rahmatullah at paragraph 90, where the compelling word is used again. Lord Millet's reasoning you find in bundle 7 of the authorities behind tab 53, MS 3929 is the start of the case, and it's a tolerably short section, beginning on MS 3944. You see the title at the top?
Yep.
And the page and a half deserves reasoning. The page and a half is what's been described in all those other authorities as compelling.
Yep.
But the guts of it, it might be thought, is between C and E. Letter C and E on 3944.
Thank you.
Yes, I see. Yep. And what Strasbourg has tended to do is not, as it were, to take that reasoning head on, but they've appear to have reasoned that in the context of state immunity at least, and there are quite a few authorities, all of them in bundle 11, but Al-Adzani is as good as any, what they've tended to do is to say, well, the action against the state in the state immunity context is not barred in limine because the defendant state can waive the immunity, at which point the thing will proceed to hearing and judgment. And in those circumstances, it shouldn't be treated as qualifying the substantive domestic legal right. It should be treated as a procedural bar. And so I described it as a straight compulsion of the reasoning boxing match.
Would you dispute that it is procedural?
My Lord, the conclusion of Lord Millet was that it was effectively substantive for the reasons that he gave and fell on that side of the line, where it would be treating, in effect, as a substantive provision of domestic law. Whether or not it can be treated as being substantively qualifying the nature of the cause of action can be an open question.
I mean, it's really something which tests the relevance of this distinction between procedural and substantive. An absence of jurisdiction isn't happily classified as either.
No. And my Lord, lots and lots of these cases, I'm afraid, are in that territory where it's extraordinarily difficult to draw a principal distinction between them. But fundamentally, one has the approach of Lord Millet, which says, well, because it operates as a principle of jurisdiction or non-justiciability in that way, you don't get into Article 6 territory at all. That's the essence of his reasoning. As I say, it may not matter terribly if one gets to justification, because once one gets to Al-Adzani on state immunity, the justification is plain anyway. But that is essentially the choice, so far as state immunity is concerned.
And which is the bit in Al-Adzani?
We've quoted it. Perhaps the easiest way is to take it from our response. Do you have our responsive document? Paragraph 87 of our responsive document. We've quoted the relevant bit from Al-Adzani. It's in bundle 11, tab 90, if you want the actual report.
You presumably say, Ms. Reedy, that foreign act of state is something which a court must take notice of and, in respect, leading it to decline jurisdiction, just as it must in respect to state immunity?
Exactly so. When we come to it, I'm simply on state immunity for the moment because you're being invited by the respondents to overrule Holland and Lampen rule on the line, on the basis of the line between.
But basically, the parallel carries through.
Absolutely. So, I mean, that's all I want to say about that. It's a straightforward fight. It's a matter for you which one you prefer, whether you want to hesitate to use the word dialogue again. But I mean, I fully acknowledge that there are a series of cases in Strasbourg which are more or less unreasoned, but are more or less consistent in adopting the line that you see recorded in paragraph 87 of our response document. That's all I want to say about state immunity. But my Lord Mance is right. We effectively rely ultimately in relation to foreign act of state on its parallels with state immunity. We of course acknowledge, in answer to a question my Lord Sumption put to me on the morning of yesterday, that foreign act of state is not required by international law, but our submission is that it reflects and is based on fundamental, long, well-recognised principles of international law. So it's the difference between something being reflective and something being required.
It's permitted by international law. It's permitted by international law.
It's permitted by international law and is squarely based on a principle which international law holds dear, is the way we put it. And in those circumstances, the difference between requirement and that status, we respectfully submit, is not a distinction of importance for this purpose. But we also rely, which is why I emphasised it a bit on going through Lord Wilberforce in Buttes yesterday, his principle. Do you remember when he was answering his question, is there a general principle?
Yes, quite, of non-justiciability.
Yeah.
Which is presumably subject to the same point. I mean, it's not justiciable, it's not justiciable.
It works in the same, it works in substantially the same way. But it also works, if one treats it as a domestic principle, it also works as a principle of domestic law, having that precisely the effect that Lord Mance has just described. And the reason I emphasise the domestic aspect is because we've got a case in the bundles, which is one of the very few I'm going to take you to on this part of the case, called Markovic and Italy, in which the Italian government was sued on Bankovic facts, on the straightforward Bankovic facts, by the relatives of those who had died in the bombing of the television station in Belgrade. And the basis for the action was that Italy had allowed its air bases to be used for the purpose of that bombing raid. They sued Italy, and Italy said, we have a doctrine, a bit like the United States, Sabatino and all that line of authority on foreign act of state. We have a doctrine called Government Act, and if it's Government Act, the courts will not review the legality of that act. So it was operating in a pretty similar sort of way, slightly different because of the Italian nuances, and we'll see what the Strasbourg court had to say about that in a moment. But so that's how foreign act of state works, and therefore, in relation to foreign act of state, operating as it does in that way, we do respectfully submit that that line of case law, which will be well known to my lords and my lady, to do with substantive rights and the limitation of substantive rights in domestic law is relevant. I'm not going to take you to them unless you want me to, but you will remember the great debate between Strasbourg and the domestic courts following my failure to persuade them in Osman on the relevant Article 6 issue and their deep misunderstanding of the principles that governed strikeouts and the way that public policy worked in negligence actions. I remember once receiving a telephone call from Mr. Emerson saying my name was being taken in vain by Lord Sumption in a case he was arguing before Lord Brown Wilkinson on the very point, because Strasbourg hadn't understood it there. But they then saw the error of their ways, if I can put it that way without disrespect, in the Z case.
I think Lady Justice Arden persuaded them of the
Lady Justice Arden, I'm sure, persuaded them. A combination of Lady Justice Arden and David Anderson, who represented the government in Z, persuaded them that it was a different thing and should be seen as a substantive limitation rather than a procedural bar in that context, because it limited the concept of negligence. And subsequent to that, you've seen and will recall Matthews and the MOD domestically about Section 10 of the Crown Proceedings Act. The one authority you don't have in your bundles, which it may be worth just handing up so you can tuck it into the same place as Matthews and the MOD, is the case in which that was directly challenged on the Section 10 point, so on this point, was it a substantive limitation or a procedural bar, in Strasbourg, which was a case called Roach and the United Kingdom. Thank you. So that could be tucked in, so it won't make the bundle too heavy, which it probably will, behind tab 47 of volume 6, which is where you find Matthews and the MOD.
Thank you.
Okay. I don't want to take long on this, but it's as well that you should have it so you can see that Strasbourg effectively agreed with the reasoning and conclusion of the House of Lords in Matthews and the MOD.
Thank you.
And you see the reference in the head note in the penultimate paragraph on page 599.
Yeah.
It was a Section 10, did that operate as a procedural bar? And bear in mind, in that case, it might be thought it's a fortiori our case, because it was operating by reference to a certificate that had to be issued by the executive. So the Secretary of State had to issue a certificate, and it was said, nevertheless, that didn't engage Article 6 for all of that. That was the conclusion of the House of Lords in Matthews, upheld. If you go into the judgment at paragraph 116 on page 633, you have the statement of general principles, this dividing line, how the court goes about doing it. It's as good an exposition as anywhere of the general principles and approach to this.
This was a 9-8 decision.
This was a 9-8 decision. It was.
Sorry, which paragraph were we at?
I was going to
116.
116.
633. Yeah.
Yeah, and 116 to 121 is the statement of general principles.
Thank you.
And the disposition of the case, effectively agreeing with the House of Lords. One sees perhaps most clearly from the first subparagraph of 123. So that gives you an example of a case where provisions of domestic law, in that case a statute coupled with the giving of a certificate by the executive, was held not to engage Article 6 because it effectively delimited on a correct analysis of how Section 10 worked, effectively delimited the substance of the domestic legal right rather than being a procedural bar, operating as a procedural bar. That's an example. The Markovich case on the Bankovich facts that I told you about earlier, that is in Bundle 11, if you would just take it up, Bundle 11, tab 86, MS 5236 for my lady's note. 5236, sorry. 5236, Bundle 11, tab 86, Markovich in Italy, Grand Chamber.
Yeah.
And you'll see the nature of the issue from the short head note on page 5236 itself. You'll see that Sir Nicholas Bratzer was one of the members of the court, and he delivered a concurring judgment, which we'll see in a moment. And some pretty familiar looking statements of general principles on 5266, paragraph 92, which I suspect will be very broadly reflective, if not identically worded, to those that we saw in the Roach case.
Yep.
And that runs to 99.
Yeah. Yeah.
And then you'll see that the key to the court's reasoning,
Yeah.
as I say, one can pick up the facts from earlier on in the judgment. What had happened was that the Italian state had relied on act of government and said that that shut matters down. Could I invite you just to cast an eye, if you would, down the dispositive paragraphs, which are 110 through to 115. So it's about a little over a page.
Again, a fairly close call, 10-7.
These are all fairly close calls because it might be thought the distinction that has been drawn is on the borderline of incoherence.
Where is the best explanation, if there is one, as to precisely how you do draw the distinction?
Well,
Whether it's substantive or procedural. I mean, it doesn't appear to...
the best explanation, don't jump round and about, but if you keep that open, the best exposition as to why that distinction is being drawn and what its principle rests on, it might be thought, is given by Lord Hoffman in Matthews and the MOD, or by Lord Hoffman and Lord Walker in Matthews and the MOD, which is it's fundamentally designed to protect the rule of law. I'll take you to that in a second, if I may. Or I'll take you back to that in a second. But just so you can see how, let me just finish with this case while we're here.
Yeah.
But you'll see, so effectively it's operating as a principle of decision, it's operating as effectively an Italian constitutional bar. So the state isn't at liberty to waive it, to the extent that's interesting at all, in terms of delimiting the substance of the domestic legal right. But it operates in effect as a principal constraint on where the court can go to. So it has real similarities in the Italian constitutional setup to foreign act of state, might be thought.
Yes. So, I mean, in both these cases, Markovich and in Roche, you could say it had something to do with the nature of the cause of action.
Yes.
It was, I mean, a military context in both cases.
Yes, although it's not quite so, in Roche it's a bit more directly related to the cause of action, potentially. I mean, Markovich, if they're pleading act of state, they're pleading something that looks very like as it were, a principle of restraint on the court's jurisdiction. You're closer to that kind of Lampen and Holland-Wolff area, where it's a principle restraining the justiciability or the jurisdiction of the court. In this case,
but because of the nature of the facts giving rise to the cause of action, if it had been just a sort of injury on the stairs in a government building,
yes, absolutely.
The court would have said most people have a cause of action
Certainly,
in this situation, and why should the state get out of it?
Absolutely, it has that link to the cause of action, but their reasoning appears to be, it's hard to pin down, but their reasoning appears to be that you don't have what you have in state immunity, which is the ability to waive, as it were. You've got this constitutional setup, act of government comes in, it operates internally as a constitutional restraint, and that constrains, therefore, where the court can go in terms of investigating that issue. That is fundamentally the same, we respectfully submit, as foreign act of state, and the way that operates. That's going to be the punch.
It's equivalent to Crown Act of State, isn't it? Because this was a...
Very similar to that.
And what the Italian court said was this was a substantive rule of Italian law which excluded any possibility of liability for the acts abroad of the or the acts related to foreign warfare by the Italian state.
That's true. That's how they analysed it, as a non-discretionary point limiting the court's jurisdiction. One can cut it anyway, but that's essentially it, my lord, exactly. And one sees that in particular, or perhaps as clearly as anywhere, from, if one is allowed to be parochial about these things, from the concurring opinion of Judge Bratzer, which starts on page 5274. And you'll see, so far as he is concerned, at 0 or 0117 at the top of page 5276. his key reasoning is in those two paragraphs at the top of that page, 5276, so paragraphs 117.
I think it's O-27.
O-27, yes, you're probably right, I'm so sorry.
Oh, don't worry. I've been trying to make sense of these numbers, but I think that's what it is.
Yes, no, you're right.
I agree.
You must be right if one looks back at 5.
It is. He says the nature of the applicant's claim gives rise to issues which are not capable of being determined. And,
Yeah.
I mean, that's your point.
Exactly so.
Yeah.
Self-imposed limitation in that way.
Yep.
I said I'd go briefly back because I was asked the question, what is the principled underpinning for all of this? That was an issue that troubled their lordships in Matthews. If you go back to bundle 6, tab 47,
Yep.
starts at 3368,
Thank you.
and the passage I had in mind from Lord Hoffman is at 3383.
Yep.
So bundle 6, tab 47, is Matthews and the MOD.
3383.
3383, paragraph 29 in the speech of Lord Hoffman.
Yep, got it. Thank you.
Can I invite you also to draw a line next door to paragraph 35 where the same point effectively is made. And it might be thought that the first sentence of paragraph 33 will prompt ready agreement.
Yep, okay.
So you'll see that his conception of this distinction, what it's truly aiming at, is a preservation of the rule of law, in effect, so that there is a distinction drawn between those things which operate as inherent principles within the domestic legal structure, either, we would say, defining the cause of action, or, to the extent that it's different, creating rules or principles, cf. Lord Wilberforce and Buttes, on the basis of which courts are restrained from going into particular areas, as compared to, and that's why it might be thought Matthews and MOD itself was a little controversial, as compared to the executive being able to shut down litigation on a whim by, for example, and that's why the House of Lords in Matthews went to such great lengths to analyse how the legislation actually worked, because on its face it looked like a certificate being given by the certificate, and it was only when you understood how the section worked that you realised that wasn't actually what was going on at all. And so we respectfully submit on the back of that line of authority that foreign act of state, which is what we're concerned about here, does indeed operate consistently with the rationale identified by Lord Hoffman in Matthews, consistently with the judgment of the European Court in Markovich and the exposition of Sir Nicholas Bratz in his concurring opinion in particular, as a positive and principled constraint. To some extent, you don't need to worry too much, in my submission, about whether or not it's a restraint directly on a cause of action, or whether it is operating as a principle which constrains the court's jurisdiction on what it will regard as being justiciable. And one can argue the toss on that, but fundamentally Markovich was about that. Whether one characterises it being a bit like Crown Act of State here matters not terribly. Ultimately, that's how it's been conceived and that's how it's been done. So we respectfully submit that for those reasons, A6 is not applicable. Right. But even if it is, in relation to justification, as I've said, Al-Adzani is a slam dunk in relation to state immunity. It's in bundle 11, tab 90. I'm not going to invite you to take that now. But so far as foreign act of state is concerned, as I've said already, we respectfully submit that 1, 2, 3 of the Court of Appeal's judgment in Belhaj is thoroughly supportive of this, if only, and this is the premise on which we get to Article 6, if only we're right in relation to the scope and reach of foreign act of state.
Right.
So if one strips out their 6 reasons, and as I say, if we fail at that stage, we don't even get to Article 6. So the premise has to be that we're right on that, and if we're right on that, we say the reasoning in 1, 2, 3 is thoroughly supportive of us. But in any event, if one stood back from it and was looking at it as a matter of first principle, we've got a doctrine which is principled, it is devised and operated by the courts. It is a principle which exists subject to principled limitations. One has in particular the 6 limitations that have been developed to contain it within its proper reach. It does not operate to remove from the jurisdiction of the courts a whole range of civil claims. That's a phrase that's often used in the Strasbourg case law when and if they get to justification. And it doesn't do that because it is targeted and its limitations are precisely designed to contain it within and only within the limits to which the rationale of the principle drive it. We respectfully disagree with the respondents who appear to be taking an extreme position in relation to justification. Their case appears to be that a restriction on access to court of this kind can only be proportionate if it is required by international law. That, we respectfully submit, is inconsistent with Markovich anyway, for obvious reasons. But we respectfully submit that that is not the right approach, and that is not what Strasbourg says is the right approach. Various restrictions on access to court have been acknowledged to be necessary and justified and proportionate by the Strasbourg court: limitation periods, security for costs. It can take many forms. Absolute parliamentary immunity. You've got that in your bundles in the A in the United Kingdom case, bundle 11, tab 87. Also justified as proportionate.
Which tab was it?
Bundle 11, tab 87. I don't have the MS numbering. I'm inviting you to turn it up. I'll give you the MS numbering just so you have it for your note. 5280.
Yep.
But that was a case about parliamentary authority and the inability to sue Article 9 of the Bill of Rights and all of that.
Yep.
So we respectfully submit that it's the wrong approach in principle to say, look for a requirement under international law. That is not in any event, that's the first point. The second point is that is not in any event how the Strasbourg court analysed justification in Al-Adzani itself. See, for that purpose, paragraph 56 of the court's judgment in that case at MS 5370. That's a paragraph page reference. It's bundle 11, tab 90. There, the Grand Chamber referred to limitations which, quote, reflect principles accepted by the international community, and then gave state immunity as an example.
Yep.
So we respectfully submit that it is not a requirement, and indeed it would be very, very peculiar were it to be a requirement. It is a proper reflection, and as we know, foreign act of state is squarely based on the principle of sovereign equality, which everyone has here, and is reflected in the monetary gold principle at the international legal level to the extent that that bears into this issue.
Yep.
One point of minor disagreement, finally, and it's the third point that I make in relation to justification. The Court of Appeal in Belhaj, we respectfully submit, was wrong in fact to suggest, and I think it was a question that was asked of me yesterday by Lord Sumption, and I was muttering about Conforti. But the question is whether or not foreign act of state is a principle that is confined to common law jurisdictions. So that feeds into this argument because it is said, well, it's a unique and strange Anglo-Saxon beast.
I didn't say strange.
No, you didn't. I think I'm summarising entirely unfairly, no doubt, my learned friends' cases, but they say it's a strange Anglo-Saxon beast and doesn't reflect international law in that way, finds no parallel, finds no analogue, and therefore can't be justified.
Yep.
Just on the point of fact, we've collected a series of references together in our case at paragraph 224, And one of those was the Conforti article that I mentioned in answer when I gave it earlier on. But for our purpose, I simply need to draw your attention to that paragraph with its collected references. And I think I did fairly answer the question when first it was asked of me, because one of the strands of answer that I gave was, it may well be that in some jurisdictions, and including in some civil law jurisdictions, the principle has no direct analogue, but other principles that are reflected in their constitutional settlements work to achieve pretty much the same effect, or to cover substantially the same ground, as the Fox and Webb article that we've referred to indicates. And you have a pretty decent example in Markovich itself. Governmental act in the context of Bankovich, of those sorts of principles operating in slightly different ways. Otherwise, my lady, that's all I wanted to say in relation to Article 6, unless there's further matters on which I can assist.
Very much indeed. Thank you. Thank you, Mr. Eady. Mr. Stain. We hear view, Mr. Hammer or Ms. Kaufman. Thank you. Sorry, I took the order from Mr. Eady. Thank you.
Yes, my lords, my lady. Despite the way in which the appellants have taken it, it works better for the purposes of our argument if we start with state immunity and then we move into foreign.
Absolutely fine.
So far as Article 6 and Article 6 of the European Convention and Article 14 of the CAT are concerned, I'm going to come back to those after Mr. Hermer has dealt with foreign act of state.
So we're going to have a sandwich, like
We're going to have a sandwich
the
in the same
appellants.
way, because
Fine.
the major issues
No,
are
it's fine.
state immunity,
Of course.
foreign act of state, and then we'll see
Seems
what
very
time
sensible.
allows.
Thank you.
Before I summarise our case on state immunity, I'd like, if we can, just to focus briefly on some of the implications of the exercise of the domestic court's jurisdiction if the appellant's characterisation, whether it be under state immunity or foreign act of state, is correct. And I'm going to do so with a couple of examples, but before I move on to those, I just want to look at the implications for the United Kingdom's liability in the domestic courts whenever it acts in concert with... Whenever it acts in concert with a foreign state to perpetrate illegal acts. The effect is one of conferring immunity upon the United Kingdom. There's no getting away from that. The United Kingdom will, through the state immunity route or through the foreign act of state route, be unimpeachable in the United Kingdom courts. It will also be unimpeachable in the courts of the foreign state where the illegality took place, because it will be able to claim directly state immunity in respect of any claim brought against it. And it may also be, if the defendant is correct that, the appellant is correct that its conception of foreign act of state is one that is widely shared across other jurisdictions, it may also be that the foreign acts themselves are immune from suit according to a similar doctrine that operates within their jurisdictions. So we will be looking at impunity, not just for the United Kingdom, but potentially for the state with which it also acted. Can I then look at some of the examples of how this might fall out? And they're obviously extreme examples, but they illustrate the point. So take the first example. The Libyan government operates a secret detention facility, and it does so in the United Kingdom. And it does so at the request of the United Kingdom, and at the United Kingdom's request, again, Libyan officials abduct the claimant in London, and they hold him in incommunicado detention in England, in that detention facility for the next 10 years. He's released eventually, and then he brings a claim against the United Kingdom government for damages. Now, the appellants accept that so far as the doctrine of foreign act of state is concerned in that scenario, a claim can be made.
Yep.
But state immunity would actually trump that, if they're right about that, because this is a claim against a foreign state which, albeit a claim in respect of their acts within this jurisdiction, is not caught by Section 5 of the State Immunity Act, which only removes immunity in respect of personal injury claims. So this is a false imprisonment claim. No cause of action would lie against either state. Second example. The United Kingdom government invites the US government to establish a secret detention facility on a United States ship which is docked in the English Channel. It's 12.5 miles from the coast just outside UK territorial waters. At the request of the United Kingdom government, those US officials abduct the claimant in London and transfer him to the ship. And upon his release, again, he brings a claim in the United Kingdom. So, how would that look according to the appellant's various characterizations of these two doctrines? His claim for unlawful imprisonment, both in relation to his initial abduction and his subsequent detention, would be barred by state immunity on the basis that there's an indirect impleading of the United States government, and the claim for torture would be barred by both doctrines.
Yep.
Example 3.
But just trying to look at the overall picture, if state immunity doesn't have the extended effect which Mr. Phillips was arguing for, then what would be the position?
Then the position would be that the false imprisonment claim, insofar as it related to the abduction of the individual in London, up to the point where he leaves the jurisdiction, could be brought.
Yes.
But any detention which took place outside British territorial waters could not be brought. So this single transaction, this single set of activities on the part of the United States in abducting him and thereby imprisoning him, suddenly meets a jurisdictional bar the moment in time that he crosses out of English territorial waters. Example 3. The United Kingdom government builds a secret detention facility, this time in Tripoli. This is a detention facility constructed for the use of the Libyan government. It equips the facility with torture equipment, provides the Libyan authorities with training in torture techniques, and then, at the request of the UK government, the Libyan authorities abduct and torture a particular individual who's due to travel from London to Tripoli. And that individual, when he eventually escapes, manages to institute a claim against the UK government. On the appellant's case, all of the claims are barred: false imprisonment, torture, according to both doctrines.
Yep.
This fourth example, and there's only one more after this fourth example relates to a private individual and not to a state actor. But the private individual, a Russian, acts in complicity with the Russian secret services. He is domiciled in London. He pays the Russian intelligence service to kill a business rival of his who is in Moscow. And the relatives of the deceased, once that plan has been executed, then bring a claim in England. On the appellant's case, the claim would be barred both by state immunity and by foreign act of state. Now that's relevant because there are cases where companies are being sued in respect of, for example, environmental damage that has been done in the locations, in the seats of some of their operations abroad, and those are companies domiciled here. and it is alleged that they have been acting in concert with the police, for example, of the foreign territory in bringing about the environmental damage or injuring individuals, particular individuals, villagers surrounding the mines and so forth. So that is a real example that would bar the claim against those companies. And the final example, the UK government enters into a formal agreement with 4 other countries, states A to D. And it is agreed by those 4 states, together with the UK, that A to D are going to abduct and torture a named individual in the territory of state A. The claimant brings a claim in the UK courts against the UK government alleging common design and conspiracy to injure. 3 of those states, A, B, and C, all admit the allegations. They concede their actions were unlawful. State D, however, makes absolutely no admissions and no response in respect of the claim.
Would you like to put these examples on a sheet of paper with the a column showing what the position is if Mr. Phillips is right as well as Mr. Eadie,
We will
and
do
what
that.
the position is if Mr. Eadie is right but not Mr. Phillips?
We will do that. We will do that.
Perhaps you go in the same small bundle as the notes we were promised by Mr. Eadie yesterday.
We'll make sure that happens. So we have 3 states who have admitted their misconduct. One
Yes,
who
we
says...
see that, the one who doesn't. And that
One who doesn't.
Yep.
So what's the position here? Well, firstly, it's not clear from the appellant's analysis whether or not A, B and C would be directly impleaded so far as state immunity is concerned, despite their omission. They haven't submitted to the jurisdiction, so arguably, even though they've admitted these activities, they are indirectly impleaded and are therefore subject to the immune from the jurisdiction. D, of course, has done nothing. Now, the consequence of that is necessarily going to be that the claim cannot go ahead in respect of anybody. So even if the admissions of those 3 states did effectively mean that they were no longer covered or cloaked by state immunity as conceived by the appellants, the whole claim could not be considered because of the position taken by D. So that's the position so far as the impunity of the United Kingdom government and the foreign states is concerned. Yep. But there are other consequences that flow from this analysis, which we also need to take into account. The jurisdiction which our courts exercise day in, day out, up and down the country, would be severely curtailed if the appellant's characterisation was correct. When the courts look at immigration claims and decide whether or not to grant asylum, they will frequently look at the past conduct of a state in relation to its citizens or a particular group of citizens, and they will make findings of illegal conduct amounting to torture, for example, or actions less than torture. Let's put torture aside. Actions less than torture. Ones that nonetheless mean that it is impossible, in accordance with its obligations, to return that individual back to the country from which they
The argument is that this is required by international convention incorporated into domestic law.
But state immunity would overcome that. State immunity, if we look at the Jones case, state immunity means you can't go there. It doesn't matter what international law requires. If they are entitled to immunity, there is no jurisdiction. And we'll come on to why there should be these sorts of exceptions carved out in relation to foreign act of state, and Mr. Hermer will address those. But in our submission, there is no rationale for carving out these exceptions if one is to start from the premise that there is an underlying rationale underpinning both these doctrines, which is sovereign equality. You can't suddenly just carve out something when sovereign equality still applies equally to that arena or sphere of decision-making. Extradition, which frequently requires the courts to look at what are the consequences if we send this individual back. Again, Article 3 can be engaged, Article 6 can be engaged. It's not just torture, it's also a right to a fair trial. And if that right is going to be infringed, you can't send them back.
Well, all one's in, I suppose another way of putting it is one's looking at risk there, isn't one? One isn't actually making findings.
Well, one may, but that risk may only be determinable on the basis of findings of past conduct. And there is no prohibition operating on our courts from looking at past conduct. And if there is a prohibition...
But they would be incidental to the main issue, wouldn't they? That may make a difference.
Well, it won't be incidental in the sense that you cannot reach a decision about future risk unless you've decided on the basis of past facts. It's absolutely critical to the determination.
Fundamental principle in family law, sir.
Yes, it's impossible. You cannot hive this off as an incidental matter. It's central to the determination of whether there is a future risk. What have they done in the past? How do they deal with people like this? Do they impose the death penalty on them? Have they done that? Absent that, there's no circumstance in which you can gain or make an assessment of the risk. Abuse of process, ex parte Bennett, circumstances where somebody is brought before the criminal courts in this country as a result of having been unlawfully extradited, that is, not extradited through the lawful process, we probably call it rendering now, into this country. In order to make that determination, the court will ask itself, what happened? How did he get here? He got here because he was rendered. Won't be able to do that again. A number 2. Mr. Eadie says that A number 2 is a special case. It's a special case because the court has applied Article 15 of CAT, but the court didn't apply Article 14 of CAT in Jones. Why is it applying Article 15 of CAT, a treaty that doesn't bind this country? It has decided to make an exception. But that is an inroad into the rule itself. And Mr. Eadie hasn't dealt with how that inroad into the rule arises on any principled basis.
What is critical, surely, about the decision of the English court in all these cases is that they have found that whatever conduct it is does not measure up to the relevant English standard. I mean, that may be putting it rather mildly in the case of some of the more atrocious acts of foreign states, but that's actually what they're deciding. They're not deciding as a critical element of it that the foreign state has acted or is even at risk of acting illegally, although that may well be a conclusion you would draw from the facts. It's therefore it's not unlike the position in Kirkpatrick, where the fact is what's relevant and not its illegal character. Here, on the other hand, the illegal character is critical.
Firstly, in my submission, it would make no difference whether it characterised that conduct in terms of illegal conduct, which it would be free to do on the defendant's submission. It's simply prohibited from doing that. It can make whatever factual findings it wants about it, but as soon as it characterises that conduct as illegal, somehow this doctrine suddenly appears and prevents it from doing that.
But it doesn't have to characterise it as illegal in the cases you're citing.
It may not have to do it, but on the appellant's case, if it does it, it simply can't. And we don't have a rule that operates in any way to prevent our courts from looking at that conduct and characterising it as legal. I will come in a minute to looking at what sovereign equality actually can justify in terms of the courts standing back and refusing to exercise jurisdiction. And I will address directly that point, my Lord, because in our submission, it makes no difference whether you make a finding of fact, the necessary consequence of which is that that conduct is illegal so far as domestic law is concerned, or you simply make a finding of fact. Neither of those activities on the part of the court will infringe the right of the foreign state to be treated as a sovereign equal. Neither will. And that's the critical point. And that's why, in our submission, it doesn't make any difference how the court characterises it when it engages in these exercises. It doesn't make any difference because it actually is not, if it characterises that conduct as illegal or unlawful, transgressing a line any more than if it simply finds that that conduct occurred.
Are you saying, Ms. Kaufman, that these various consequences are being advanced against you? In other words, for example, extradition. Are you suggesting that the submission made against you is that in extradition proceedings the court can't inquire into the...
No. My submission is the
and
logical...
what does the Extradition Act actually say?
My submission on it, the Extradition Act does make provision, for example, for Article 4, for Article 6, considerations to be taken into account, Article 3 considerations, but on a state immunity argument...
Doesn't that, on any view, limit the Foreign Act of State doctrine?
But on a state immunity argument, that would trump. State immunity would trump that statute, necessarily.
I see. You say it's a necessary implication
Yes.
of the argument that's made against you.
Yes, it would necessarily trump it. But take, for example, A and the United Kingdom. That's not a jurisdiction that is exercised as a result of statutory provisions which enable the court to look at these matters. It is a matter of common law. Take again the abuse of process jurisdiction in Ex parte Bennett. Again, that is a common law creature. There's no statute that overrides Foreign Act of State in that situation. The point I'm making in relation to Mr. Reedy is that it is a logical consequence of his arguments that these matters that the court adjudicates upon day in, day out would be taken out of the court's
A
jurisdiction.
logical consequence of Mr. Phillips's argument rather than Mr. Eda's, isn't it?
Well, you say
Well,
both.
Oh, you say both?
Yes, you've made both on Act of State and State immunity. Yep.
It's a logical consequence of both, because what he can't do is explain how, whilst remaining faithful to the principles that he says underlie these two doctrines, you can carve out these exceptions.
Well,
He hasn't-
can Parliament carve out exceptions through statute, which the courts can't do?
It could.
But then
Parliament
what Lord Hughes is effectively putting to you is that that's what's happened in the examples you've given.
Well, not in all of them, as I said.
No, the question
Abuse
was
of
about
process.
the question was about extradition. In
Yes.
an extradition, there clearly is a
Yes.
statutory. Your other examples are of common law.
They're of common law. And therefore one has to confront this. Parliament can't possibly be taken to have overridden those.
Asylum, which isn't.
Turning now to state immunity and state immunity alone, there's one issue that we have to deal with, which is going to take us to the El Masri case. Mr. Eady said yesterday that as a result of a decision of Mr. Justice Leggett, it is now the position with respect to Mr. Rahmatullah's claim that he doesn't have a claim in relation to what happened to Mr. Rahmatullah when he was in the hands of the Americans. And that is not correct. The correct position is that Mr. Rahmatullah has an extant claim, which the defendant has accepted being a claim brought under the HRA, is not caught by Foreign Act of State, and also appears to accept that it's not caught by state immunity on Mr. Phillips' conception of the doctrine, which runs like this. Mr. Rahmatullah was captured by the British. He was then transferred to the Americans while still in the jurisdiction of the British because they had authority and control over him. When they transferred him, they knew, or ought to have known at that stage, of the risk he faced of ill treatment and unlawful detention at the hands of the United States. What we have also brought, in addition to that, in our pleaded case, is a claim alleging that the United Kingdom's responsibility extended temporarily beyond that moment of transfer. And we've argued that even when he was physically out of the control of the British, there was nonetheless sufficient control over him for the purposes of jurisdiction under the Human Rights Act that we can claim in respect of their failure to get him back. Now, it is that aspect of the claim that Mr. Justice Leggett has said falls out with the jurisdiction and we cannot claim in relation to. So we have an extant, viable claim in Mr. Rahmatullah's case, which Mr. Eady accepts the court is going to be allowed to adjudicate upon because it is not covered by either doctrine. And the question here is, in respect of state immunity, does the Human Rights Act override the State Immunity Act? Who knows? It may or may not do. But let's assume for a moment it does do, and there is an extant Human Rights Act claim, then the problems that Mr. Eady has spoken about, in addition to the reasons that should prohibit the court from adjudicating upon this being based in sovereign equality and comity, that is the practicality problems, are ones that the court is going to have to confront in any event. That is simply not a problem that the court can get away with. Because if one looks at the El Masri judgment, one will see that the court did, yes, it's true, the court was looking at the risk of his ill treatment at the point of transfer, but it was then able freely to look at all manner of material about what the United States had done in the past in order to determine the question whether or not the Macedonia should have known about the risk that was faced. And in relation to the detention, the Macedonian state was held liable and responsible for all the detention of the applicant, including the detention after he moved from Macedonia, because he spent some time in the airport in Macedonia, albeit in the hands of the United States. He was then transferred to Afghanistan, and for 3 months he was in Afghanistan, and the court held that the Macedonian state was liable in respect of that unlawful arbitrary detention which was affected by an unlawful rendition. All findings of illegality made by the European Court of Human Rights in respect of the United States conduct. So there's no getting away from the need to adjudicate upon those matters. And if I could just, for your lordships and my lady's pen, give you the references in our amended particulars of claim, which make good the points that are cases about transfer and not just about what happened after transfer in relation to the United Kingdom's failings. That's the amended particulars of claim are in C2, page 1142 at paragraph 164, that's Article 3, 167, Article 5, and 171 for Article 6, because there's also a claim in relation to liability for the fact that Mr. Rahmatullah was then detained for 10 years without any access to a court. The relevant provisions are parts of the judgment of Mr. Justice Leggett, which make it clear that his analysis of where Mr. Rahmatullah's claim fails on jurisdictional grounds is in Al-Sadoun 219, that's the second volume of authorities, tab 19, and the relevant passages are paragraphs 133 to 134, 135 to 136, and yes, it's just 135 to 136.
133 to 136, okay, thank you.
Oh yes, 133 to 136, yes.
But your page number?
Oh.
2125.
Page 2125, I'm grateful. I tried to make sure this morning I got all the page numbers, and I think I failed, I'm afraid.
It's okay.
Well, we're trying to bring everybody along with us, but we're not succeeding at the moment.
So, in our submission, these are obviously radical consequences, and they are radical consequences that run entirely contrary to what the courts do day in, day out, in exercise both of statutory but also common law jurisdiction. And in our submission, there is, on analysis, no coherent, let alone a compelling justification for the courts to take the course that is urged upon them by the appellants. Can we take, for example, the justification based upon sovereign equality? So one starts from the principle that amongst states they are all equal and they are all sovereign within their own sphere of operation. One clear implication of that is that one state should not question what another state does within its own territory, within that sphere of sovereign influence. So when it comes to the acts of a state within its own territories, another state has to stand back and leave be. And that's the acts of the legislature, the acts of the executive and the acts of the judiciary. Now, we know there are exceptions to that. The Oppenheimer principle is one such exception. But what that finds expression in our law, is the conflicts rule. That is exhausted by the conflicts rule. Some kind of interference and influence in the business of another state. And this is the point that my Lord Mance was making about how that translates in the judicial context. Making a finding that somebody has behaved in a particular way, factually, or translating that finding into, and that was illegal according to our common law, does not trespass on the sovereign authority of another state. It does not assert sovereign authority over that state because it does not purport to assert its power and control. The judiciary only does that when it makes legal determinations of right or liability in respect of somebody's interests or obligations. But otherwise, and what happens when it does that, that's one aspect of the judicial authority. And what that does is it then opens up the rest of the judiciary's powers. You make those findings of liability, then it entitles you to make recompense for any wrongdoing that's been done by way of judicial orders. And then it entitles the court to enforce those orders for recompense or for the delivery up of property or whatever else it might be. But that is the assertion of judicial authority. Beyond those two directions of travel, where does sovereign authority take you? In our submission, once a state has stepped outside its own territorial boundaries, that sphere of influence that is its alone, why should another state stand back and refuse to question its actions? Why? Why can't our legislature or our executive say in Parliament, or the government and the head of state say in a speech in Downing Street, on the steps of Downing Street, what Iraq and Saddam Hussein have done is a violation of the fundamental rights of its people. It's torturing, it's abusing them, there are disappearances and so forth. Why can a state not do that? Because sovereign equality is a principle that binds the state in all its aspects, the legislature, the executive, and the judiciary. It is a principle that applies between states and all its organs. But why can't states do that? And if the legislature can do it and set up, for example, some sort of committee, parliamentary committee, to inquire into the conduct of the British government in concert with its foreign partners, why can't the courts do that? If all they are going to do is to criticise, albeit in terms of a finding of illegality, the conduct of that foreign state, or the executive set up an inquiry of some form, which is not a judicial inquiry, but is a public inquiry of some form, which again embarks upon the same exercise. Why not?
Why couldn't we, on that basis, adjudicate upon a death or by, for example, American drone or bombing? Could we adjudicate in the domestic courts upon a death arising from the Italian bombing of Belgrade?
Well, that's state immunity.
I see. So,
that's direct. That's a direct impleading of that state. That's a direct impleading. We are going to adjudicate upon you if that arose in a context in which all that the court had to do was to make a finding that something illegal had happened, which had consequences for another defendant in the claim, then yes, that adjudication would be necessary.
So if it arose indirectly, we could do it. If it arose indirectly as a...
Yes, as long as you are not attaching legal liability as a court to that conduct.
It's legal liability.
It's legal liability. That is the assertion of authority. And anything less is simply a finding, maybe a very, very unhelpful finding in terms of...
Not a binding finding, because they're not parties.
Not parties.
So doesn't I'm sorry, no, wrong time. At some time, does a declaration do that or not?
No, a declaration would have that effect, but they would have to be a party.
Yes, if there was a declaration that it happened, but they weren't a party, that wouldn't bind them.
No, it wouldn't bind them in any way. There would be no legal liability that followed from that. You couldn't then say, and United States, you need to compensate the defendant in consequence of that conduct.
It would be binding us between the parties to litigation, that's your point.
And what we'll see is that all the case law, domestic case law, even the ICJ case law, works according to the same principle because they share Lord Mance's understanding of what impleading means. What does it mean to be subject to the jurisdiction of a court? It has a very particular meaning.
Is that particular meaning a convenient time? Good. Thank you very much. We'll resume again at 2:00. Court's now adjourned.